So what's making headlines in Trump's criminal trial in New York is all the salacious details. Trump's former lawyer stole from the Trump Organization, he lied on and off the stand, and Stormy Daniels' X-rated descriptions of her alleged one-night stand with Trump. But what the media isn't talking about is the most important fact in this case, what the charges are based on. Welcome to Newspeak, I'm Kellum. So if you've been following Trump's trial, you've probably gotten the blow-by-blow of Michael Cohen and Stormy Daniels' testimony.
But the judge also suggested Daniels was difficult to control.
How Trump looked in the courtroom.
He's stretching out like this. He's like fist bumping with attorneys.
And how the defense's witness thumbed his nose at the judge.
Staying sassy in the courtroom again, rolling his eyes at one point.
But lost in all the horse race reporting on this case is arguably what's most important, what this case is built on. So going back to April 2023, when Manhattan DA Alvin Bragg announced the indictment, he said Trump was being charged with falsifying business records in the first degree.
Under New York state law, it is a felony to falsify business records with intent to defraud and an intent to conceal another crime.
In the indictment, Bragg cited New York Law 175-10, which says it's a Class E felony to falsify business records when the intent is to either commit another crime or conceal a crime. Bragg claimed that Trump covered up the hush money payment of Stormy Daniels by having his then lawyer and fixer Michael Cohen pay Stormy Daniels' lawyer to keep her quiet. Cohen says he took out a home equity line of credit, paid Daniels' lawyer through a shell company, and then had Trump pay him back monthly as if Trump were paying him for services as a lawyer. Now, what seems clear is that there was an attempt to hide the paper trail of this payment, which I should say here doesn't necessarily mean Trump was guilty of anything. Trump claims he never slept with Stormy Daniels. Whether or not that's true, she was trying to sell a story ahead of the 2016 election that he did. But there could be other reasons, like not wanting his family to find out, that could be the reason for the payment. Now, going back to the charges, Bragg says that there was an underlying crime that Trump knowingly and intentionally was trying to conceal. However, the indictment doesn't say what the crime is. When he was asked about that during the announcement of the indictment, his first response was that New York law doesn't require that he cite an underlying crime.
Sure. So let me say as an initial matter that the indictment doesn't specify that because the law does not so require.
Now, to any legal analyst watching this case, this is a major red flag. The whole case is resting on Trump covering up a crime, but Bragg didn't even say in his indictment what that crime is. Now, he did go on to list in very vague terms what crimes he thought could apply. Take a listen.
First is New York state election law, which makes it a crime to conspire to promote a candidacy by unlawful means. I further indicated a number of unlawful means, including more additional false statements, including statements that were planned to be made to tax authorities. I also noted the federal election law cap on contribution limits.
Okay, so let's take those one by one. The first is creating false records to promote a candidacy by unlawful means. Now, that's again really vague because he doesn't specify what the unlawful means are. You could argue that anyone trying to run for office is conspiring to promote their candidacy, but paying hush money to someone shopping around a story about you isn't illegal. Now, if instead of paying Michael Cohen with his personal money, he paid Cohen with campaign contributions, that might be one thing, but he didn't. Now, the second so-called crime he listed was that these false records were planning to be made to tax authorities. Now, these records were made in 2017. If Trump had submitted them fraudulently to the tax authorities, he would already have done so. But a big part of this case is that Cohen says Trump not only reimbursed him for the hush money payment, but that he paid him extra to cover the taxes that Cohen would have to pay on the money. Because Cohen paid taxes on this money, it's not clear what tax violation Trump might have committed, and saying that these supposed false statements were only planning to be made to tax authorities makes it even shakier. The last alleged crime Bragg listed was the limit on federal campaign contribution limits, but it's hard to see how that would apply either. First off, it's not illegal for Trump to donate to his own campaign. If so, RFK Jr.'s running mate Nicole Shanahan would be in jail now for donating $8 million to their campaign. Now, if Bragg is talking about Cohen making an illegal campaign contribution, Well, that's already been dealt with. In 2018, Cohen pleaded guilty to making campaign finance violations for the Stormy Daniels payments and even served jail time for it. Now, the other glaring big red flag here, to use a bit of legalese, is called a jurisdictional issue. Bragg is a state prosecutor, and it's unclear, at least from everything I've read, what authority he has to charge Trump based on a federal election law. Remember, Trump was running for the office of U.S. president, not state governor, and so if the federal government thought Trump had committed campaign finance violations, it should be the federal government charging him, not the Manhattan DA's office. That would be like if I were a cashier at McDonald's and the CEO of McDonald's defrauded investors, which didn't include me taking legal action on behalf of the investors. And it's not just me saying this. The former Manhattan DA, Cyrus Vance Jr., said this was a glaring issue with the case. He told NPR, as a matter of New York law, unlike federal law, there are novel issues around using the false statement statutes in connection with committing a crime that violates federal election laws. Now, Vance Jr. had a chance to bring this case while he was in office. He said the reason he didn't was because the feds had asked him to stand down. That would make sense because federal elections are a federal legal matter. But here's the other thing. Because Vance Jr. didn't charge Trump while he was in office, Bragg is now charging him 7 and 8 years after these alleged crimes occurred. And that brings up the statute of limitations. The statute of limitations means that if you commit a crime but enough time has passed, you could get off scot-free because most crimes have an expiration date. Now, the statute of limitations on misdemeanors in New York is 2 years and felonies 5 years. And since the charges in this case are 7 and 8 years old, Bragg shouldn't have even been able to charge this case. However, the statute of limitations for certain crimes were extended by New York Governor Andrew Cuomo during the pandemic. Now, to my reading of it, those extensions didn't apply to Trump's case. But in his executive order, Cuomo specifically excluded the time that the defendant, in this case Trump, was outside of the state. Since Trump was in Washington, D.C. for 4 years during his presidency, Bragg is using that loophole to prosecute him now. But the underlying crimes in this case still don't make sense, which is why Trump has been able to argue pretty convincingly that
it's a fake trial. They have no case. This is Alvin Bragg doing it for political reasons.
Now, I'm not saying that if you watch or read mainstream media, these problems go unmentioned. You do hear about them occasionally.
You know, they've got to tie this case into another crime. They failed to really specify what the other crime is.
I need to call this out. We collectively, prosecutors, are pushing the boundaries of due process here. The general back and forth in the courtroom today was the defense lawyers saying, Your Honor, please tell the jury specifically what the other crime is, right? Prosecutors have to prove falsified records for another crime. Defense lawyers were begging him. They have to know what the other crime is. And prosecutors were saying, no, let's keep it very vague and general.
This trial should have been a federal case about violating election laws instead of a falsifying business records in a state case, which is very convoluted.
Number two, I don't believe this case belongs in state court, and I think it rests on a legally tenuous theory.
Have you seen a smoking gun?
There's no smoking gun here.
There's no smoking gun here.
But what I see happening is that the media is so focused on the courtroom drama, the fundamental issues in this case are being largely overshadowed. Now, if you're a media nerd like me and you want to get the latest stories on the media, please subscribe to my channel. And if you like this video, please share it with your friends and leave a comment for the algorithm down below. Once again, I'm Kellum, and this is Newspeak.